Good morning and welcome to this HR Advance webinar where we threw out a challenge to you to ask Paul anything. I'm Alison Williams, Managing Editor at HR Advance, and with me today is our own IR expert, Paul Munro, and he's had a lifetime of experience in answering your workplace-related questions. Welcome, Paul.
Thanks, Alison. Hi, everybody.
Well, first up, I'd like to thank our listeners for sending through your questions. We've sorted them into categories so Paul can get through them as quickly as he can. And I just want to make it clear, though, that from necessity, he won't be able to give detailed answers, but really will be just giving a general overview just so that we can answer as many questions as possible. So I'm not going to waste too much time because we've got a lot of questions to get through, and I'm going to pretty much stay in the background from here on. So let's get started.
Thanks, Alison. Thanks, everybody, for listening. Yeah, I put them into categories of unfair dismissal, redundancy, leave, and modern awards. So how many we get through today will depend how quickly I can get through each question. The unfair dismissal ones would usually require a fairly detailed answer. I'll try and just get to the nub of some of the issues that might be raised by some of these questions. So you'll notice there with the unfair dismissal questions, these are 4 that came in about specific matters, but I guess as in generalising them, the nature of the questions is that, for example, the first one is how do we dismiss a long-term employee? I guess the only difference between any other kind of employee is that the Fair Work Commission tends to give a little bit more. Well, a long-term employee, they're working on a presumption that the person has been a good employee for quite a number of years. So any warnings or any behavioural issues or anything, Fair Work Commission's usually working on the idea that these are developed for some other reason. The person's not a bad employee necessarily, or has been a good employee for a number of years. So the things like how long for warnings, those sorts of things are the sorts of things you should give a little bit more rope to somebody who is a long-standing employee. There was a very large company, actually, a multinational company, that dismissed an employee after 20 years for insubordination, and the employee was pretty rude to their supervisor. Excuse me, but they went ahead and dismissed the person, and the person was reinstated with full pay. So even large companies that have access to advice and resources, legal advice and resources, can fall into the trap of jumping too quickly to dismiss somebody who'd been there 20 years. In that case, the Commission said the employee was probably not what you'd call an exemplary employee, been warned a few times over 20 years, but bottom line was they'd been there 20 years and what they did wasn't sufficiently harsh enough to warrant dismissal. In other words, dismissal was overkill in that sort of situation. So I guess with long-term employees, you've just got to give them a little bit more time for behavioural, particularly if they're behavioural issues or performance issues, before actioning the next part of the disciplinary process. Can we dismiss somebody who provides false documentation? Once again, generally the answer is yes. Once again, though, it depends, I guess, on what's the false documentation. For example, if someone claims to be 30 years of age and they're only 25, for example, and that's of no particular consequence, that's, if anything, could even be put down as an error, although that's not a mistake, I wouldn't have thought. But say someone who is 18 but says that they're 21, that can have a material difference as well, in that the rates of pay, that some awards, for example, have junior rates of pay, so the person may be gaining a benefit from actually that sort of providing wrongful information, deliberately providing wrongful information. Things like a driver's license, if someone says that they've got a truck driver's license and they've only got a motor vehicle license, then obviously the employer is quite within their rights to dismiss somebody on the basis of that for all sorts of reasons, including it may even jeopardise their insurance work as well with their motor vehicles and the like. So false documentation, I guess it depends on whether or not is it a requirement of the job. In other words, would the person get the job whether that documentation is right or wrong or whatever anyway. Certainly in terms of licensing requirements and registration requirements of people, someone needs to be registered in a particular occupation or profession, then certainly the answer would be yes. Another common question that came through was about warnings and do they have a use-by date, and should they be in writing? The answer is anything in writing is better. Verbal is just as good, but it's more difficult in if you're appearing before, say, the Fair Work Commission. You're appearing before a third party who has no understanding of the circumstances of the particular matter, so that therefore the onus is generally on the employer to prove that warnings were given and the like. An employer can make notes, particularly there's a little bit more slack given to small business employers, and this is with the Small Business Fair Dismissal Code. Employers that employ fewer than 15 employees. They're not as stringent as it would be for employers who employ 15 employees or more, but it's still best to keep a record because you can actually then refer back to that if any future warnings are required. Do warnings have a use-by date? The answer is, well, they do, but it depends on what's being actioned. For example, if it's absenteeism, that's probably something that can happen fairly frequently if there's a warning. Whereas if it's a performance-related issue, and particularly if it's, say, where the reporting requirements or the reports that come through are monthly or every 2 months, for example, then obviously that then extends the length of the warning period to measure whether or not the performance of the warning has had the desired effect of improving the person's performance. So the warning relates to basically the nature of the behaviour or the performance that the person is being warned against. Generally, Commission's in its comments on this in decisions, you get the impression that anything longer than 6 months requires almost a special circumstance explanation. So anything longer than 6 months, you're starting to look at issues that require some explanation. So if it's appropriate, 6 months would be the maximum I would suggest that you have a warning operate for in terms of that. The other thing is too that comes up with warnings is whether can the person is the warning about the same thing? In other words, if someone's late, is that they get a warning and then say 2 months later their performance is poor, does that mean that another warning means that they apply separately? Well, the answer is no. A warning should not only relate to just taking a warning with respect to the specific action that the warning's being issued for, but it also should refer to or any other behaviour or performance that might happen within the warning period as well. So then you're covered for all sorts of different types of behaviour or performance as well. These are the sort of the factors to consider, which I've just really talked about. The other thing is that with anything with a dismissal, there's a valid reason, but then there's also a question of the procedure as well, whether it's investigations, if anything is required there, whether that's appropriate. So you firstly need a valid reason, but there's all these numbers of different factors that are required. The warning process, for example, is part of the procedure, that the person was made aware of the inappropriateness of the behaviour or the performance. So they're the sorts of things that you need to take into account as far as unfair dismissals are concerned. Certainly before you dismiss somebody, I'd recommend that you seek the advice of your employer association or a legal advisor. Circumstances do differ. There are obviously general things about eligibility, for example, about whether they've been employed 6 months or 12 months, depending on the size of the organisation. And the Fair Work Commission determines whether it was harsh, unjust or unreasonable. So they're looking at 3 different things. It doesn't have to be all 3. It can only needs to be one of those 3 things. A lot of variables, a lot of discretion involved. A tribunal probably best avoided if you're in the sense of if anyone confidently goes into an unfair dismissal matter thinking that they will get a positive result, then I think they may have an issue or they may have a problem. They might be very disappointed at the end result in a lot of the instances that come through. Had some questions on redundancy. one of them actually just asked the general question of what are the essentials for making someone redundant? Well, there's two things with that question. An employee doesn't become redundant, the job does. So it's the employee who was assigned to that particular job. It's not the employee who is redundant, it's the job that becomes redundant. So that's the first thing, to ensure that you're looking at the job, you're not looking at the individual as such, in respect of all of that. The other thing is that, particularly if any person is being made redundant, that your selection criteria are appropriate. In other words, that they're based on objective factors or criteria, and they're not based on, say, discrimination or discriminatory issues. For example, the things like saying, oh, bad attitude, or not a team player, things like that, they're very subjective reasons for not for selecting somebody for redundancy. Whereas if it's referring to training or operational requirements of the business, those sorts of things based on more objective criteria, then that's appropriate in those sorts of situations. So with respect to that, particularly where things like, as with the third question there, is can an employee on parental leave be made redundant? This is particularly the case where things like that, where on a superficial situation, there are a lot of protections for people in certain situations where they fall into a particular category that could be discriminatory. For example, a woman who is who's pregnant or who has given birth and has caring responsibilities, then if the reason for the dismissal was that, then the employee has protections under discrimination law, under the Fair Work Act as well, either through unfair dismissal or general protections matters as well, which are becoming increasingly the case as well. With the situation with the parental leave issue, I would those sorts of situations is that the person can be made redundant if they fall within the company's objective selection criteria. It doesn't offer a blanket protection being on parental leave, but you've got to be very careful, and particularly if somebody takes, say, a general protections issue rather than an unfair dismissal issue, the onus of proof is on the employer. So there's a reverse onus of proof with respect to that. So you've got to be, in other words, the onus is on the employer to disprove that the reason was because the person was dismissed because they were absent on parental leave. So once again, with those sorts of issues, you've got to be very, very careful about your objectives criteria as to who you select for redundancy. The other question is, does redundancy pay always apply? I guess this is more a situation where, once again, based on the size of the employer, where the employer employs fewer than 15 employees, the National Employment Standard doesn't apply for the redundancy pay. But some awards apply to small business employers. It's an award-based entitlement, not a statutory entitlement. Very few awards actually provide for it, I think, and they're in quite specific industries. I think, for example, the clothing industry and the timber industry are two off the top of my head I can think of that have a provision regarding small business employers having an entitlement to, employees of small business employers having an entitlement to redundancy pay. Generally, the answer is that redundancy pay applies to employers who employ 15 people or more, and that's the provision under the National Employment Standard under the Fair Work Act. So that's just the factors to consider. Once again, another issue is another thing is to see whether or not there's redeployment opportunities within the company. The smaller the employer, generally, obviously, that's not an option in most cases. In larger places, I would investigate whether there are possible redeployment opportunities, and if you think that a particular job, an employee could possibly do another particular job, offer it. Don't presume that the employee is not interested in accepting something that may even have a lower remuneration, because anything that's acceptable is acceptable on the basis of what the employee finds acceptable. I've come across instances where an employee has accepted an offer of part-time work as opposed to taking redundancy, or is offered a lower paid position, which has duties which they can still perform. They have the skills and the experience to be able to do the job, and they've actually taken the job because the person has accepted that rather than the alternative, which is unemployment. So certainly, if there are jobs available within an organisation, certainly offer them, because as much as an employee may not, particularly if there's a substantial drop in remuneration, may not accept it, they may as well. So always make that offer in that situation. There's consultation requirements with redundancy as well. So they're normally a requirement under the award. There's usually a standard model consultation clause in there. So once again, and that's the opportunity where issues like redeployment can be raised. They're the sorts of things that consultation can have different outcomes, as opposed to a presumption that the redundancy will occur as a matter of course. I'll get on to some leave questions now, and leave always creates a lot of inquiries. Had one, I guess, because of Easter, the public holidays and the like. There was a question that came from somebody who said they had a shift worker who was sick on the holiday and they didn't have any sick leave left. Do they still get paid for the public holiday? Well, the answer to that is yes, because the public holiday actually takes precedent over personal leave in any case. For example, even if the person did have a personal leave or sick leave balance, it wouldn't come out of their sick leave or their personal leave balance. It would actually be regarded as payment for a public holiday. So in that particular circumstance, the person would be paid for the holiday in any case. A lot of questions also relate to whether someone can forfeit payment for a public holiday if they're absent the day or the day before or the day after without a reasonable excuse. It's quite common for people to probably to take time off before or after public holidays, particularly around Christmas or Easter, where there's a group of holidays. The answer is no. That was an old provision. There was quite a few awards years ago that used to have a condition like that. A lot of old state awards and several federal awards had a condition where the payment could be forfeited. Problem now, or the thing now, is that the National Employment Standard, public holidays now fall within the National Employment Standard, and it basically says if the person, if the holiday falls on a day the person would normally have worked, then they receive payment for the day, regardless of what happens around the holiday. Certainly, it would be a matter for disciplinary procedures if the person was unable to give a reason or provide suitable evidence the day before or the day after a holiday, but they certainly can't forfeit payment for the public holiday. Another question regarding the public holidays is that how does it affect annual leave, personal leave and long service leave? Well, if a public holiday falls during a period of annual leave or personal leave, it is the public holiday stands. In other words, it's not a day of annual leave or it's not a day of personal leave. So that's the effect that a public holiday has in terms of paid annual leave and personal leave under the National Employment Standard. Long service leave is different. In fact, any answer to long service leave in this webinar is relates to, it was always under the understanding that you've got to check your relevant state or territory long service leave act to determine the specific entitlement. With public holidays extending long service leave, some state and territory legislation extend it, others don't. Not many don't. For example, in New South Wales, it's the public holiday extends the period of the leave, but it's once again, it depends on the particular circumstance of the which particular state or territory long service leave legislation applies. So it's not a blanket thing. There's no standard provision regarding the extension or not of a public holiday with long service leave. So check the relevant state or territory long service leave legislation to determine that. There was quite a few questions too on carers leave. And there seems to be, I must admit, I pick up a misunderstanding that by a lot of employers of what the nature of carers leave is. There was a scenario that was put by one of the questioners about a person who had to go and pick up their child from primary school. There was an arrangement apparently where a friend would pick up the child from school, and the friend was actually unable to pick up the child because of other circumstances. So the employee told their employer they had to go and pick up the child from school, and it was probably about 2 or 3 hours before their usual finishing time. The employee claimed carers leave. The employer questioned whether or not that would be a circumstance where its care is being provided. Well, the answer is that the employee would be entitled to carers leave in that sort of circumstance. Carers leave talks about providing care or support for a member of the immediate family or employee's household, or an unexpected emergency. And the courts seem to have taken a broad view of what's meant by unexpected emergency. There was always a presumption that that wording was referring to a medical emergency. Well, certainly it does include medical emergencies, but the courts have handed down decisions over the last few years which have broadened that to also include situations such as that. There's been another circumstance from memory where a child couldn't get to school because of flooding. There was been flooding. I think there's been others relating to bushfires and things like that as well. Natural disasters that have prevented a child from attending school, and the parent has to stay home to look after the child. They have also been considered circumstances where the person is eligible to claim carers leave. So it's unexpected emergency. Bear in mind that if these sort of circumstances crop up, unexpected emergency doesn't just mean medical emergency. It also means other circumstances as well, such as the, for example, the two that I've just mentioned. Excessive annual leave. How much is too much? The modern awards were varied, fortunately, a couple of years ago now. Probably I think it was around middle of June 2016. Which inserted a standard clause into the majority of modern awards that allow the employer to be able to send somebody on that has accrued an excessive amount of annual leave. Generally, that's 8 weeks for day workers and non-continuous shift workers, and 10 weeks for shift workers. So there's mechanisms within awards now whereby you can send somebody on annual leave if they've accrued more than 8 weeks. There's also inserted in those clauses a mechanism whereby an employee can request leave as well if they have an excessive amount of annual leave. So there are provisions in there too about employee requesting excessive or to take leave where they have an excessive amount of annual leave. So have a look at the applicable award. With award-free people, it's generally the same. You'd be probably better off using that as a guide in any case as to what's an excessive amount of annual leave with an award-free person. Considering the Fair Work Commission regards that as being a reasonable benchmark, then if you point to that as part of your policy with respect to those people, then that to me would be a reasonable period to, or a reasonable amount of leave to use in your policy. Another common one is question that came up was about dismissing people on annual leave, whether that's permitted. The answer is no. The Fair Work Commission actually has handed down a number of decisions with respect to annual leave, and they regard that annual leave and notice of termination are two mutually exclusive entitlements. So the thing there being that the person has to come back from annual leave and then given notice or payment in lieu of notice, as the case may be, because the Commission regards the two as two mutually exclusive provisions. Slightly different, there's very little case law on the situation with respect to somebody on personal leave, and that's presuming the person isn't being dismissed simply because of their absence on personal leave. That's another question again. There's old case law that suggests that you can terminate somebody on, say, if it's redundancy, for example, you can terminate somebody on personal leave because the period of the leave may be indeterminate. In other words, you don't know when they're going to be coming back, necessarily coming back from personal leave. There are old cases that have determined that, and surprisingly, there hasn't been anything of any recent note on that. So it seems that there is a difference with personal carers leave as opposed to annual leave, but certainly the courts have determined that you can't dismiss somebody on annual leave. You've got to wait till they come back from annual leave.
Can I just hop in there, Paul?
Yep.
So can an employer still dismiss the person while they're on annual leave if they give them payment in lieu of notice?
No.
No, so they literally have to be
No, that was
present.
actually a circumstance that a full bench of the
Mm.
Commission heard probably about 2 or 3 years ago, where people were made redundant. And the decision was made while there were some people on annual leave, and the company made people redundant and paid them out in lieu of notice.
Mm.
And the Commission said, no, the payment in lieu of notice can only occur on the day back, the first day back from annual leave.
Right.
In fact, it might have even been a close-down situation. It was still annual leave. It was an annual leave close-down situation, I think, from memory. I can't remember the exact circumstance. But certainly they were quite specific about saying it's not just the notice, but it's the payment in lieu of notice. In other words, that they're saying that even the payment in lieu of notice is a mutually exclusive condition to annual leave as well.
Okay, yeah, thanks.
Changing from full-time to part-time with long service leave. Once again, as I mentioned before, but the actual calculation or method of calculation of determining ordinary pay in that situation is determined by the relevant state or territory long service leave law. But generally speaking, legislation talks about the current rate or the average over the previous periods. That can change depending on the relevant legislation. In some jurisdictions it's 5 years, and some it's 3 years. So generally there's two mechanisms. There's usually the current rate of pay or the average over the previous 5 years or 3 years, whichever is the greater. So surprisingly, when someone changes from full-time to part-time, the longer that say someone has been employed part-time for 3 years, for example, and say the act is 5 years, it's amazing how wage increases continue to creep up, and that the average, the full-time rate or the average over the previous 5 years, even the current part-time rate can sometimes be greater than the average over the previous 5 years, even when there was full-time employment involved. So that's generally what the company has to go through in determining whether or not it's the current rate or the average over the previous 5 years or 3 years, whichever is the greater. Had one where a company asked about somebody who was dismissed and then re-employed within 3 months. Generally speaking, once again, the 3 months is something that varies depending on the jurisdiction. 3 months is the most common one. 2 months, there's some that have 2 months from memory as well. If it was termination by the company, then generally that's when this mechanism kicks in about being re-employed within a certain period of time. Off the top of my head, I think Queensland, it doesn't matter who terminates the employment. If the employee resigns and is re-employed within 3 months, then there's continuity or recognition of the previous service with the employer. Generally, though, this mechanism is triggered in legislation, in long service leave legislation, where the termination is by the employer and the person is re-employed within the particular period of time, 3 months or 2 months. So check that with the particular legislation. Certainly if the company terminated the employment, generally these mechanisms kick in no matter what. But if the employer resigns, that may be the end of it in terms of that particular mechanism. So it's not just a blanket termination by anybody. certainly check the legislation to determine whether or not it's whether the termination needs to be by the employer or by the employer, or whether it also covers termination or resignation by the employee. There's a surprising number of employers who think that employees don't have to give the same period of notice that's required to be given by the employer under the Act. Certainly the National Employment Standard requires the employer, when the employer is giving notice, to provide a minimum period of notice based on the amount of service, continuous service that the employee has with the employer. Generally though, certainly with award-covered employees, generally the termination of employment clause in the applicable modern award will refer to the NES as the amount of notice that's also required to be given by the employee as well. Generally, it excludes the over 45 component in the National Employment Standard. The person gets an additional week if they're over 45 and they've been there more than 2 years. That part doesn't apply generally in awards where the employee is required to give notice, so the employee is not required to give an additional week if they're over 45 years of age. Another one's about the employer refusing a request to take leave. Generally, the employer needs to have fairly good reasons for doing so. I guess that particularly the smaller the employer in terms of the number of employees there, operational requirements are certainly one of the things that the employer can use as an objective reason for refusing an employee's request to take annual leave. But in most instances, the answer is no. The legislation does allow it, and in fact, there's all sorts of other reasons as to why the Act allows 4 weeks annual leave a year for employees. There's also workplace health and safety sort of angles to this as well, as people having time off from work to rest and recover from working. So there's those sorts of issues as well that can over time become an issue, probably not in 12 months, but certainly if the employer continually refuses an employee's request for annual leave, there are all sorts of other issues that can come into play, not just the reasonableness or otherwise of refusing the request. A lot of this too can be helped. I know, for example, here at the chamber, when a person's hired, chamber closes down for 2 weeks at the year, but also has it indicates what are the busy times as well. I know a lot of employers actually stipulate that because of the nature of the business, probably even lead up to Christmas, for example, might be is a common time of year where I've seen policies where they say that there need to be specific or special reasons as to why an employee would request that. So I think once again, it helps if employees are aware of times of the year in particular. You can avoid the issue of operational requirements preventing somebody from agreeing to let somebody take annual leave if the company knows its own business, in the sense that it knows when it's going to be busy, when it's going to be not busy, things like that. If employees are reminded of this, certainly at recruitment time, but also have it in a company leave policy or the like, then that would go a long way to also adding to the reasonableness of the employer saying, well, no, we told you that we weren't able to do this, and the circumstances you've explained to us for requesting it aren't sufficient to overturn that particular requirement. There's also, you get a lot of, conversely as well, where the employer is directing people to take leave with an annual close down. There was a rather large multinational accounting firm that made the front pages a few years ago, where they introduced a close down at Christmas. So we're talking about chartered accountants and all sorts of professional people, and it made the front pages of the paper because people were complaining about that. Now, that was a company that introduced it. In other words, they didn't have anything in their policies that said that this was a possibility in the future, or that it was something that they could cover in their particular policies. They had to introduce it, and they copped a lot of flack from that, and a lot of publicity, which was not necessarily in their favour. They certainly had the right to do it, but once again, it's there's not necessarily good outcomes come from this in terms of some of the animosity that's created by some of these things where the company doesn't pinpoint these sorts of things as well. So when it came in about an employee on maternity leave working for another employer, I guess the answer is yes, but it would depend on the work. I mean, I couldn't imagine somebody doing the same work for another employer when they're on parental leave, because the presumption there is that the person's got to be providing care to the child. So that's the reason for the parental leave. And once that circumstance ceases to exist, the person then is no longer eligible to be on parental leave. That's the difficulty with that. I mean, I can imagine jobs where somebody might be able to, say, work from home and do work and still provide that care. Maybe in those circumstances. So the answer is there's certainly nothing in the legislation that says that can't happen, but it all is dependent on whether or not that person remains the caregiver or the primary caregiver to the child. Once that circumstance changes, then the answer is the person's no longer eligible to be on maternity leave. Cashing out long service leave, once again, it's actually not as common as you'd think. It's probably half-half. Cashing out literally is dependent on the relevant state or territory long service leave legislation. So, for example, in New South Wales, the answer is no. South Australia, the answer is yes. Western Australia, yes. Queensland, yes, under certain circumstances. So, and Tasmania, I think, as well, you can cash out. So it's common, but not. Once again, it depends on the jurisdiction. A number of larger companies that were negotiating enterprise agreements in the early days failed the boot because they actually put in a cashing out provision for long service leave, or they wanted to put that in as a clause in their prospective enterprise agreement. And the Fair Work Commission knocked it back because these were companies that operated in every state and territory, and it fell foul of the Better Off Overall test because the term also would have applied to employees, say, in New South Wales and the ACT and the Northern Territory, where the legislation doesn't permit it. So if you're negotiating an enterprise agreement, be mindful of the fact that state legislation like long service leave can still impact and actually can't be overridden by the provisions of a enterprise agreement under the Fair Work Act. So these are the sort of factors that I've actually just gone through then with respect to these forms of leave. So I'll move on to some of the award questions there are. Some were quite specific, and so I probably tend to avoid those ones, but there are some that offer or that were asked on things that were sort of a more general nature. It says, are there minimum hours that you have to offer a casual employee? Well, the answer is it's not so much how many hours do you have to offer. Then there's the question more of the minimum payment if a casual employee is asked to actually show up for work. Once again, this depends on the applicable modern award. So the modern award will determine what is the minimum payment for the day. It can go from 2 hours, I think it's 2 hours from memory in the retail award, to transport, I think, is 8 hours. So it's the award certainly determines what is the minimum payment for any time worked on a day by a casual. So a casual, there's no problem with a casual just coming in and working half an hour. But the problem from the employer's perspective is that you then may be required to pay a minimum of, say, at least 2 hours. But if they're a truck driver, it could be a whole day's pay if they show up. So be mindful of the fact that there's a minimum payment as opposed to there being a minimum number of hours that need to be worked by a casual on a particular day. Had a few where the manager claims to be covered by an award and whether that's possible. The awards themselves determine coverage. There's nothing that would prevent them from having a classification in there regarding a manager. Most, at the most, majority of awards would have a provision in there for supervisors at that sort of level. But as to people with management responsibility, generally awards wouldn't apply where the duties are literally that. In other words, the responsibility of being able to hire and fire, having budgetary control over their particular area, those sorts of things, which are the duty of the manager, the award would not apply to those sorts of things. And that's not necessarily said in the award, but this has been determined by decisions over the years by the various courts and tribunals about someone who is a true manager, for want of a better description, say involving those sorts of responsibilities. The answer is no. The award, it wouldn't be presumed that the award would cover those sorts of people. Where it becomes a bit of an issue is that in a lot of places, people are given the name manager, when in fact they may not necessarily be exercising management responsibilities. In a lot of instances, they're given the title manager to maybe justify being paid a little bit more than somebody else doing similar sort of work within an organisation. Be very careful of misnomers like that. The court drills down to whether or not the duties are actually being performed. Calling somebody a manager doesn't mean the award may not necessarily apply if there is scope in the award. For example, there's a licensed clubs award that has classifications for secretary managers or for managers. So there's certainly nothing to stop an award from having a provision or a classification for a manager. Not many do. In fact, that might be the only one I can think of off the top of my head that actually does contain classifications that cover management as such, people with that sort of responsibility. So don't look at the name, look at the duties that the person's performing. Can an award cover employee work 40 hours per week by agreement? The answer is yes. The reasonable hours provision in the Act is just that. It talks about reasonable hours. A lot of it is to do with workplace health and safety issues as well. A lot of it revolves around that, whether the employee was advised of the reasonable hours. Once again, it gets back to a bit similar to the annual leaves situation I was talking about before, where if someone's advised of this before, that at the time of recruitment, that the job requires a 40-hour week to be worked, then that's fine. Certainly, if the employees agree, like all these things, if the employee agrees, then that's fine. If they refuse it, then that's something that the employer would need to look at in terms of being able to direct the person to do that. Asking somebody to work 2 hours overtime in a particular week, I don't think would be unreasonable in that circumstance. The other thing to bear in mind in that sort of situation is that if they are working a 40-hour week, make sure if they are award covered people, that the extra 2 hours is being compensated for in there. If you're paying them, say, an annual salary, that the overtime component or the overtime penalty rate is included in the 40 hours, or in their pay, in their annual pay. Another question was, if a new employee doesn't fall under an award, are they then award free and fall under the NES? Gets back to, I suppose, the manager question related to something a little bit like that before as well, bearing in mind that the NES applies to everybody, whether they're covered by an award or not. And even if a term of an award is inconsistent with the National Employment Standard, the National Employment Standard would apply and would override the term in the award. So the being not covered by an award doesn't mean that there are conditions of employment that other conditions of employment are then negotiable, but the 10 terms under the National Employment Standard aren't. You can certainly provide better than that, but they are the minimum provision that you need to pay. So that's pretty much it for the moment in terms of the questions that have been asked. I noticed that there's been a few coming in as well. I'm not sure how we're off for time.
You've done incredibly well, Paul. I didn't think we would actually get through them all, but that was a marathon effort. So, yes, look, we won't go over time now. There have been a few extra questions and we will endeavour to get those answered for people who sent them in. I want to thank you for all the great advice. I'm hoping that those that are listening that have sent in their own questions, that they're happy there. They've got the answer. And also, don't forget, if you're an HR Advanced subscriber, that you have access to the workplace advice line if you're a premium level and above subscriber. So you can call them anytime with your workplace related questions and get an answer straight away. So don't forget that. That's a really great benefit from your subscription. So I hope you found today's session useful. Please feel free to drop us a line at customer service, that's all one word, customer service @hradvance.com.au if you have any follow-up questions, and make sure you log on to HR Advance, that's hradvance.com.au, and log on for practical management of your HR work. If you want to revisit today's presentation, then you will be getting a link to watch the replay in the follow-up email today. So keep an eye on your newsletter. We'll be sending you details of our upcoming webinar for next month. So thank you for listening.
Thanks very much, everyone.